Hi, my name's Matthew Boersen, and I'm the Managing Partner of Straight Path Wealth Management. And today we're going to talk about another question that we get a lot from our retiree clients. But it's one that's not quite as fun as maybe some of the other ones we've talked about. And this is, if I die tomorrow, what legal documents do I have to have in place to make sure my family's taken care of? And there's kind of two different groups that we talk about. There's a core group of documents that we'll talk about first that we recommend everybody have. And then kind of some optional add-ons that for some people, these may be a good choice. So first, let's talk about the core documents that everybody should have. And these are a will, power of attorney, healthcare power of attorney, and beneficiary designations. So first, a will. And a will is what directs where your assets go after you die and who you want to execute your wishes on your behalf. So a will names the beneficiaries and who's going to inherit what and in what percentages, and the executor or administrator of your estate. It's really important to have a will because if you don't have one, then the state laws for where you live govern who gets your assets and who controls them. And so by naming a will, you take back control from the state and get to name specifically what you want to have happen. A power of attorney is the second document that we recommend everybody have. And a power of attorney is something that lasts during your lifetime. So a will kicks in after you've passed away. A power of attorney is something that is in existence only while you're living. And a power of attorney is a designation on who you want to make financial decisions on your behalf while you're still living but potentially incapacitated. And this is important because you could go into a medical procedure where you're temporarily unable to make decisions, or you could be getting to the end of your life and no longer able or capable of making consistent, good financial decisions. And during either of those situations, a power of attorney would be able to step in, make decisions that are in your best interest on your behalf. And so pre-creating a power of attorney before you actually need it's really important because you'll be able to make the decision of who's best and who's in the best place to be able to make these decisions on my behalf. In a very similar vein, you have healthcare power of attorneys. Just a healthcare power of attorney exists for things that are healthcare related instead of a financial power of attorney like we talked about a second ago. These may be different people. You may decide that you want one person to be your healthcare power of attorney and another person to be your financial power of attorney. That's totally okay. People have different personalities and are better in different situations. Attached to that healthcare power of attorney is also going to be something that we call a statement of wishes. And that statement of wishes just allows you to give some guidance to the person who's making healthcare decisions on your behalf to what you would want them to make. It allows you to kind of pre-think about some of these ideas and give some guidance and some direction. This is especially true when you start talking about end-of-life decisions, where they might be making very difficult decisions on your behalf and not be able to talk to you on what you'd want to have happen. So we have a will, power of attorney, healthcare directive, and then the fourth one isn't a specific document in and of itself, but is more of a process that we recommend, which is to put beneficiary designations on all of your retirement accounts and life insurance proceeds. Life insurance proceeds, as well as retirement accounts, which would include 401ks, 403bs, IRAs, move outside the normal will-based process. So you could have named somebody as your inheritor on the will, but if you've named somebody different on your beneficiary designations, on your IRAs and 401ks, those are going to supersede what you've decided inside your will. So it's really important to make sure that you look at your beneficiary designations on a regular basis, and especially if you've made a change to your will, making sure that you don't also need to make a change to your beneficiary designations is really important. And so those are the core group of legal documents and legal processes that we recommend all of our clients to go through. But there's two additional kind of optional things that may be a good fit for you depending on your situation. And first would be creating a trust. And a trust has some benefits that a will doesn't have. And so a will, you get to direct your assets, but your will directs those assets, passes those assets on to the next generation, and then ceases to exist. A trust allows you to put some more parameters around it, as well as potentially avoid probate, which means making the process of your estate passing from one generation to the next move a little bit smoother. The trust also allows, especially in the case of minor beneficiaries, for you to put some more restrictions around the withdrawal privileges, where someone doesn't inherit the entirety of the money all at once when you pass away, but instead you can span it out over a set of years or a set of circumstances. So again, a trust allows you a little bit more control, allows you to put some potential withdrawal restrictions in place, and potentially allows you to avoid probate. And then last but not least, we will encourage people in certain situations to create what's called transfer on death forms. Very similar to beneficiary designations on 401ks or life insurance proceeds, transfer on death forms allow you to name a beneficiary directly on things like bank accounts or normal non-retirement investment accounts. This allows those assets to also bypass the probate process and go directly to where you want them to go, making the process a little bit smoother and not quite as cumbersome for your loved ones who are going through this at what is already a very difficult and emotional time. So the core recommendations that we recommend everybody have are will, power of attorney, healthcare power of attorney, and beneficiary designations. And then for many people, a trust as well as transfer on death forms are good add-ons to also make the process go even a little bit smoother and give you a little bit more control on what happens after you've passed away. If you have any questions about this, and especially how this works inside a retirement plan and pairs with the retirement plan and what this looks like as you're making the transition to retirement, please don't hesitate to reach out to me or my team. This is our specialty, and when we bring these things together, making sure that everything meshes together and makes sense. Please reach out to me or my team. We'd be more than happy to sit down with you and look to make sure that the estate planning and the documents that you have in place match what fits into your overall retirement plan.